well. Now, I will say that we did amend our petition recently after our last hearing to include additional defendants, which we became aware of due to some stuff. And he may have been included on that, but I believe the non-suit, and that was what we discussed at the last hearing, was effective as to him. And he just wanted to make sure that he attended the last one just to make sure.
Okay. If I do not believe any of our claims filed yesterday affect them, and if I was mistaken in them being part of the case, still it's easy. I'll file an amended petition removing them.
And I don't mind doing the same, Your Honor. If we probably in error just had the same style, just like Mr. Murphy did.
Still easy. I'll file.
Sorry, we had a technical itch that I was issue that I was trying to resolve. It resulted in that feedback, but I think we've gotten that resolved. Let me look real quickly at the file. I don't recall, but I wasn't looking through the file for this purpose. I don't recall the non-suit. Not saying it's not there.
Your Honor, if I may direct you to the motion which was filed July 22nd of last year, and your order which was signed August 6th of last year.
Of last year?
Yes, yes, sir.
If I recall that being not of all, I recall Mr. McNeil's client being Rita Leak, not Donnie Leak. And I believe you had non-suited Donnie Leak, Mr. Kirby. Is that correct?
No, the motion for non-suit declares that we are non-suiting Rita K. Leak, her heirs and her successors, Donnie Leak, and Amber Doyce Taylor.
Okay. Okay, then you're correct. I believe they're out of the case.
Okay, good.
Okay, I will add that to my to-do list. I'll file an amended pleading, just removing them to make it clear.
Okay, let me get us on the record and make some announcements, some Zoom related announcements.
If I may, one more thing, Your Honor, just to follow up from what we're talking about. We did amend our petition. We did include 5 additional defendants who would be potential override owners. I received notice yesterday that 2 of those services have been returned, executed. One against Copperhead Resources and the other one against Wolfpack Minerals. So I would anticipate answers from them in the near future.
Okay. All right, thank you. Let me get us on the record. Call cause number 1321. Loosely referred to as Surge versus the McBride heirs and the Sisler heirs. That is a very loose description. That's not the caption of the case. This is a hearing being conducted by remote video technology using the Zoom protocol to conduct this hearing. The proceeding is also being live streamed on the court's YouTube channel to satisfy some concerns about public access or access of the public to the courts. That is being done to comply with Office of Court Administration guidelines and Supreme Court directives. In that regard, in case there is anyone from the public attending through viewing the court's YouTube channel, as well as those who are participating in this actual Zoom video conference, the court expressly prohibits anyone from recording any portion of this proceeding by any means, electronic or otherwise, other than the official court reporter who is present with the court in the physical courtroom, as well as in this virtual courtroom. He is transcribing the proceedings just like he would do if we were in person in our proceedings, and thus is the only one authorized to do so. That said, this is a hearing on a motion to compel responses to discovery. I have to toggle back and forth, and so let me save the toggling back and forth in order to look at the actual pleading. Who filed that motion?
It was me, Your Honor.
All right. Ms. Wade, did you or your clients join in that motion?
We did not, Judge.
All right. And did Shanna Gibson join in that motion?
She did not, Your Honor, though some of the discovery will affect us, and we have been paying attention to what has been produced.
Okay. All right. So let me begin with announcements in this order. Mr. Murphy, are you ready to proceed on this matter?
I am, Your Honor.
And Mr. Kirby, as the primary respondent to that motion, are you ready to proceed on behalf of your clients?
Yes, Your Honor, I'm prepared to proceed on behalf of Surge Operating and Moss Creek Resources.
Then Mr. Ramirez, on behalf of Shanna Gibson, although not having joined in the motion, nevertheless interested, if nothing else, in the motion, are you ready to proceed on behalf of your clients?
Yes, we are, Your Honor.
And likewise, Ms. Wade, on behalf of the Sisler heirs that you represent, are you ready to proceed on behalf of your clients?
Yes, Your Honor.
All right, Mr. Murphy, I'll hear from you.
All right, Your Honor, this is Patrick Murphy representing the movement Sheila Wadleigh, Jan Cruz, and Doyce Taylor. We are moving to compel plaintiffs Surge Operating and Moss Creek Resources to respond to the discovery that we have served on them. A little backstory, let me just kind of remind the court of the facts. I mean, it's pretty well known. Underlying this is a title dispute between the parties that are loosely known as the McBride heirs and the Sisler heirs. And I, along with Mr. Ramirez, represent the 4 McBride heirs, and Ms. Wade represents the 4 Sisler heirs. And there are some minerals that have been leased by all of our clients in favor of what was initially Tall City Exploration, and Surge and Moss Creek are the assignees of those oil and gas leases. And Surge and Moss Creek have been drilling on that land the Dragon A wells. There are 4 of them. I just loosely call them the Dragon A wells. The first one was produced in May of 2017. That's when it was completed. About a year and a half later, almost 2 years later, Surge and Moss Creek filed this interpleader claiming, well, we don't know, is the title dispute between the McBride heirs and the Sisler heirs going to go in favor of the McBrides or the Sislers? And they filed that interpleader, said, we have money from royalties that we are seeking to interplead into the court and be discharged of liability for. They waited almost 2 years after the first well was completed. And in fact, as Mr. Kirby has mentioned earlier, only recently were all the necessary parties even served with notice of this suit. And likewise, not counting the new claims that we added yesterday, my clients also have counterclaims against Surge and Moss Creek and cross claims against the Sisler heirs regarding declaratory judgment on the veracity of the oil and gas leases, the title to the minerals, etc. So what we have right now, the main issues are, 1, interpleading of the disputed funds. I think everyone here recognizes that there is a dispute regarding who the Sisler heirs or the McBride heirs is entitled to these funds, but what we still do not yet know, because Surge and Moss Creek have been unable to provide it to us, is how much money is rightly supposed to be interpleaded. Your Honor, is it possible for me to share my screen? Right now it says the host has disabled attendee screen sharing.
Oh, let's get that resolved. We don't do that initially.
Took care of it, Judge.
Okay. You are, or
Okay.
it has been?
All right,
It has
there we
been.
go.
Okay, there.
I am pulling up, is my screen on everyone's screen now?
Court has it.
Okay. Your Honor, this is the discovery response that Surge and Moss Creek served 2 months ago. And I just want to scroll down and show what we're dealing with. Interrogatory number 4, we've asked for each well and unit identified in response to interrogatory number 1. And in their response, they listed the Dragon A wells. Please state the monthly royalties separately on a well by well and month by month basis that you are currently holding in suspense relating to your petition and interpleader in this litigation from the date of first production to present. And we got a few objections that it's burdensome, overbroad, and a fishing expedition, and it's not proportional to the needs of this case. And then we got this long narrative answer that, by the way, was not verified. That's part of our motion to compel, is the plaintiffs have still not verified their interrogatory responses. But looking at this, I am unable to tell if holding title in suspense to an amount equal to $279,871.37 is the amount, or then further down, they say there's an issue of a previously unleased life estate totaling $792,599.86. Or further down, whether it's the $1,072,471.23. Mr. Kirby and I have had multiple conferences about this response since we filed our motion to compel, and eventually last week, what I'm about to show, this is a pay deck regarding the suspended funds that Mr. Kirby provided. And so now the number is $399,183.23. And I understand it's going to get higher every month because new oil and gas production happens. But what is also troubling is Jan Cruz, Doyce Taylor, Shanna Gibson, and Sheila Wadleigh all have the exact same interest. And so it's confusing to my clients why the suspense figures are different for Cecilia Cruz and Sheila Wadleigh at $85,000, but $114,000 for both Doyce Taylor and Shanna Gibson. So that's one of the things we're trying to get to the bottom of, is what's the interpleaded amount? And part of this problem is how erratic these answers are. And likewise, my clients, and I believe Shanna Gibson as well, they have one half of the minerals are not in dispute. Only one half of the Mamie Clanton minerals are in dispute in this case. So we have been getting money from the not undisputed minerals, but the checks that our clients have been receiving have likewise been erratic, and they're not the same every month for each of the clients and for each of the mineral owners. And so in order for us to figure out how much, I'm going to stop share, for us to figure out how much is being interpleaded, we don't need to know just how much Surge and Moss Creek claims it's holding in suspense. We also need to know how much is it paid to each of these 4 people in the past to confirm that they're not holding anything in suspense that really shouldn't be held in suspense, or to make sure that they're properly doing their math. So that's one of the big things that this discovery that we're asking for is past royalty payments and suspended fund payments. A subsidiary issue to that is we're dealing with an interpleader, and in interpleader cases, oftentimes an interpleading party such as Surge and Moss Creek may be entitled to their attorney's fees out of this interpleaded funds, but only if 1, they did not unreasonably delay in bringing their interpleader, and 2, only if they're truly disinterested stakeholders, meaning they're going to be in the exact same financial position, regardless of whether the Sisler heirs or the McBride heirs ultimately prevail on the title issue. And then lastly, another issue in this case is, well, after this case is resolved, Surgeon Moss Creek presumably will continue producing oil and gas on these minerals. And we're trying to get to the bottom of, with our declaratory judgment issue, of how is Surgeon Moss Creek going to allocate net revenue interests for each of these possible owners under either circumstance. So those are the issues that we're dealing with. Now moving forward to the content of our motion to compel. One, in both my client's original answers, this is over a year ago, we had served Surge and Moss Creek with a standard request for disclosure. It's been over a year, they still have not responded. So first, we're moving to compel for them to finally respond to this. Number two, and this is the more critical thing, is we are moving to compel on their responses to our interrogatories and our requests for production. I'm going to share my screen again. All of these interrogatories and requests for production are geared toward either one of the three things that I just discussed: figuring out past and suspended funds, figuring out whether or not Surge and Moss Creek are entitled to attorney's fees, or three, figuring out what the net revenue interest of every party is going to be based on the outcome of this case. And I'm going to show a few interrogatories and requests for production responses just to show what's going on. Interrogatory number 3: for each well and unit identified in your response to interrogatory number 1, which, as I said before, they answer the Dragon A wells, please state the monthly royalties separately on a well-by-well and month-by-month basis paid to each of the following persons from the date of first production to present. And then I listed 11 people, which were all the parties to this case who may be claimants. It includes Rita Leak, Donnie Leak, and Brenda Leak, which we discussed they may be dismissed from this case, but it still applies to the remainder of the parties. And their response, reminder that we've asked not for the royalties that are in suspense, this asked for the royalties that have been paid. They've lodged numerous objections that it's burdensome, harassing, a fishing expedition. The documents are obtainable from some other source that is more convenient, which, as an aside, they did not provide those documents, and saying it's not proportional to the needs of the case. And then they answered no royalties related to the disputed interest have been paid. Well, that's not what we asked. We're asking what royalties have been paid in general, not related to the amount in dispute. Number 4 is the corollary, which we talked about a few moments ago, where we're asking the same thing, not just what's been paid, but what's being held in suspense. These are relevant to, as I mentioned before, calculating how much money are we dealing with. The 4 attorneys in here right now, me, Ms. Wade, Mr. Ramirez, and Mr. Kirby, should be able to sit down without the court with all the information in front of ourselves, and we should be able to agree. There shouldn't even be a dispute. We should be able to agree how much is properly being interpleaded in this case. And we need that information from Surge before we can move forward. Now I'm going to turn to the request for production, and I'm going to show request for production number 2 or number 3. This is the same thing. This is the document request corollary to interrogatory 3, asking for, from the date of first production to present, images of all the royalty statements from you to all of the following persons for each well and unit identified in response to interrogatory number 1. And they've objected that it's cumulative, not proportional to the needs of the case, and the documents are obtainable from some other source that is more convenient, less burdensome, or less expensive, and that it's overly broad. Well, this is relevant to showing how much has been paid in the past. Likewise, I don't know how it's obtainable from some other source that is more convenient. They're the creator of these royalty statements. So they are the most convenient source for this stuff anyways. And then likewise, requests for production number 4. This is kind of the catch-all of past royalty payments. From the date of first production to present, the complete pay deck in its native format, showing all gross and net production, gross and net royalties, net revenue interest, and net payments to all of the following persons relating to production from each well and unit identified in response to interrogatory number 1. This is the giant master Excel spreadsheet that shows how much money, how much oil and gas has been sold, allocates it to each individual owner, nets out taxes, nets out everything. It's like the master sheet. And their response, once again, I said this request is asking for the pay deck of what has been paid, not the pay deck of what's in suspense. And they responded, plaintiff has not created a pay deck concerning the disputed interests. Well, as I mentioned earlier, Mr. Kirby and I have had some conferences. Mr. Ramirez has been a part of these conferences in the last 6 weeks, and they've trickled in a few documents. But initially, in response to all of these requests for production, plaintiffs did not provide a single document. They trickled in a few oil and gas leases, they trickled in some division orders, and then last week, they provided us with this pay deck that I was showing earlier. This is the master pay deck for all the 4 people, all the McBride heirs. And this is really small. This is, I printed off just the PDF of the first page of the second tab, and I'm zooming in, and this is the exact thing that we're asking for. And on the far right, it shows deck decimal. And this is their pay deck for the disputed interest that in their response, they claim they didn't create. So we're kind of left in the dark being told all this stuff is irrelevant and overbroad and we didn't even create this stuff, when in fact they have. So all of those requests and interrogatories are trying to get to the bottom of how much money are we dealing with? And likewise, the second portion of what we're dealing with is Sturgis and Moss Creek are trying to get their attorney's fees out of the interpleaded funds. And part of that is, have they unreasonably delayed in bringing this interpleader action? And as to part of that, we've requested, for example, in request number 7, all internal Moss Creek communications relating to the disputed royalties and minerals that are at issue in this litigation. Such request will show, okay, when did they start talking about it internally? When did they find out there was a problem? Did they delay? Likewise, we've asked for all communications between you and Surge relating to the disputed royalties. Same thing, how long have Surge and Moss Creek been discussing this? And just FYI, my clients, we served almost identical requests on Surge and Moss Creek, and they provided a single response. So there's also a request for all internal Surge communications, which is what the footnote right here that Mr. Kirby provided. So there's these exact same things to Surge as there are to Moss Creek. Then lastly, in request 9, all communications between you and Tall City Exploration related to the disputed royalties. Reminder, Your Honor, Tall City Exploration was the original lessee who took the leases of both the McBride heirs and the Sisler heirs back in 2014. And we got the exact same response to all 3 of these, that it's overbroad, burdensome, vague, and a fishing expedition, that it fails to identify the document sought with particularity. And this last one kind of confuses me. They're claiming that they don't have to produce it because these internal communications with Tall City and communications with one another are their protected property. And as a result, said none. And as a result, with this, we aren't able to look into how long has Surge and Moss Creek known about this. Should they have brought this interpleader sooner? We need this information to assess in part to assess whether they are entitled to attorney's fees out of these interpleaded funds. So, Your Honor, in all of this, these requests, all of these interrogatories and requests for production are tailored to one of these needs that I have been discussing, but all that I have received from Surge and Moss Creek thus far are objections. And under Rule 193.2E, since there's so many objections, if there any of these objections, even if they are valid, which I dispute, I believe every single one of these requests is entirely relevant and within the scope of the rules, even if any of them were valid, since they've been obscured by all these unfounded objections, under Rule 193.2E, the objections are waived anyways. And similarly, under 193.2A and B, Surge and Moss Creek were required to comply to the extent that no objection was lodged and explain to the extent that they were not complying. And likewise, they haven't done that here either. So likewise, I'm still in the dark about what exists, what I'm dealing with, what I'm even trying to compel. And so, Your Honor, in conclusion, all we're asking is that they be ordered to respond to the request for disclosure, their objections be stricken, that they be ordered to fully respond to these interrogatories and verify their responses, and that they be ordered to fully respond to and provide all their requested documents. With that, I'm about ready to turn it over to Mr. Kirby to respond, but as part of this motion, we do have a request for attorney's fees, and if the court is inclined to grant that, I would request that before this hearing is over, that I be allowed to call myself as a witness to just to prove up the attorney's fees incurred.
All right. You'll be allowed if we get there. Mr. Kirby?
Thank you, Your Honor. Mr. Murphy is correct. We have been in numerous discussions since he's filed his motion to compel. And I have been working to try to resolve these. First, let me say this. I don't want to burden the court with what's going on from our firm perspective, but this was initially filed by an attorney that was no longer with our firm. A lot of things happened in the beginning with regards to not initially filing or serving and noticing that there should have been 5 additional defendants in this. There were some hiccups. I personally am a retired litigator, and I view this as a interpleader action where, hey, my client, I'm an oil and gas title attorney. I write title opinions. That's what our firm does. And so I viewed this case as, hey, our client has funds. We need to get these. We don't care who these funds belong to. They belong to, between Ms. Wade's clients, Mr. Murphy's clients, Mr. Ramirez's clients, but really don't have any interest in this. When the discovery came, I am trying to, number one, and I've told Mr. Murphy this, and said I'm trying to do as little work as possible to get the money into the court. Most of my time that I perform on this, I don't even bill to my client because it's an interpleader. It really is. It's an interpleader. My client just wants to get rid of the funds. When the discovery was served, I didn't understand, I guess is the best thing. I didn't understand the purpose of the discovery. I am trying to do as little as possible to keep the attorney's fees down on Surge's side. Whether the court would allow us to recover them is for a later decision, of course, but I'm trying to keep costs down. And I guess I did not understand the purpose of Mr. Murphy's discovery request. When he filed the motion to compel and all of that, we've been trying to work through this. I've been trying to get him whatever he wants. But in the end, yes, number one, I do want to amend these discovery responses so that they are proper. We did provide him a spreadsheet last week. I have not had any feedback from that spreadsheet because that would be something that I would definitely want to include in the revised or supplemental discovery responses. This is taking a while. I'm not saying it's not. I am trying to get information out of my client. My client is located in Houston. We are still experiencing quite a few COVID issues in Houston. I recognize Borden County may not be, but most offices are permissive work from home. People go to the office 1 or 2 days. And it's very struggling to try to get information. What I used to be able to get in 2 days is now taking a week and a half, in addition to the fact that one of the division order analysts, the main one, came down with COVID and he was hospitalized from that. So it's taking a little bit longer. I do want to respond and I do want to try to get to the right number. I recognize that in the interrogatory responses that were initially provided, and when we initially did provide the interrogatory responses with regards to those amounts, there was some confusion on our side with regards to those numbers. We talked with Mr. Murphy. We have worked to get the interest that was initially in the Donnie Leak life estate out of suspense. I have asked for an off-cycle check to be cut in that interest. I thought it was going to make it to the last royalty check. It did not, but I've asked for that to be cut. Mr. Murphy has also circulated a proposed to me. I don't know if Ms. Wade has seen this, but and this was actually circulated amongst council a year ago as well, a proposed order for us to just interplead the funds and get out, and it fell through. He's recirculated one. I'm running that up the chain of command with my client to make sure that they're cool in their legal department with the wording to get the funds interpleaded in the court and everybody kind of move along their way. I recognize that this is not in the time manner that we have all wanted, but it's what I'm dealing with right now. I have, and in regards to Mr. Murphy's request for disclosures, not a problem. My apologies. I've been working, trying to get the more meat of the information as opposed to disclosures.
So in essence, you agree that the motion to compel should be granted?
I agree that we need to provide additional information, yes, and that's what we're working on. If we want to argue specific objections, I would like the opportunity to amend, if that's allowed, or supplement, and see if that satisfies Mr. Murphy.
How much time?
Mr. Murphy, how much time?
It's up to Mr. Kirby on how long he thinks he needs to do this. They've been sitting on this for 2 months, and I have sympathy regarding COVID. I understand that things are slower and different. I mean, we're in Zoom right now rather than in the courthouse, but they've never asked for extensions before. This is the first time that they've ever said, "Oh, we're having trouble, but we won't want to give you everything." And they've had 2 months. I would 2 weeks max would be my request for amended responses and withdrawal of objections and verified answers. And
Your Honor, I'm not going to. I will agree to amending my discovery responses, but withdrawing objections, if there are valid objections, yes, if there are objections that need to be withdrawn, I will. Now understanding and viewing this in a different light.
One of the objections that is most concerning to the court is the objection, or maybe it's more of an observation, that this material can be obtained in a less expensive, more expedient, I don't know if that was the right word or the word that was used, manner from other sources, without identifying who or what those sources might be. Without identifying who or what those sources might be, I don't consider that a very good objection.
Understood, Your Honor.
Here's on essentially a very simple matter at the moment. It's very simple at the moment because it seems that the material sought is germane and important to the ultimate disposition of the case. And Mr. Kirby, you sort of recognize that and recognize that that should be disclosed and in a reasonable amount of time. My inclination is to give you a reasonable but limited amount of time. Those two terms are so vague that we haven't just given anything definitive. And I anticipate we'll do something definitive. I would like to, before I just arbitrarily set some definitive time frame, I want the input from the attorneys. There's a couple of other matters. One is the additional parties to the case may have some effect on how that material or where that material needs to be disseminated, and whether or not the additional parties have any interest in the material that we're talking about, the discovery material. So let me take a side trail for a moment and ask about the other three newly joined defendants. Do we know what the status of that service of citation process is?
Yes, Your Honor. Service is still pending on those three. I had it right here. I anticipate getting Majestic Minerals back very shortly. Copperhead was served on 9/17. Wolfpack was served on 9/16. And then the two individuals being Drew Scott and Grant Singleton. Hopefully those will come back soon. Given limited discovery measures and people not wanting to be in contact with people, I do know that my process server served everyone via certified mail. So the two that I received back did come back via certified mail, return received. So, and I have the returns of service as well. So I would anticipate within the next week or two, but I can update the court with an email to your court coordinator tomorrow and ask him, hey, where is this? And what have you gotten back? Have you gotten a return, like an undeliverable or anything like that specifically?
Well, if service was had on August 16 and August 17,
Sorry, September.
I'm sorry, I thought you said.
Sorry, my mistake. It is September. The citations were not issued until the beginning of September.
Okay, all right. Then they haven't had a time to respond. Let me tell you that service by the process server by certified mail is subject to a valid objection, and that objection may be lodged by me, that's not valid service. Service by certified mail is a valid method of service if it is issued by the clerk and not by the process server.
If it would please the court, I have no problems in having people double served.
All right. Well, if they file a response, it doesn't matter. That will take care of it. But I just mentioned that as a potential problem.
Yes, Your Honor.
The other matter that we have at least alluded to is the issue of attorney's fees. And there are two different types of attorney's fees. One with respect to the motion to compel, the other with respect to the interpleader's recovery of attorney's fees as a result of them interpleading the parties and the funds. It's easier to address the interpleader funds or attorney's fees associated with interpleading. Those are usually lesser fees because there's not much involved other than the getting it all together and filing it with the court. Although with multiple parties and things of that nature, that can be more than the typical bank filing an interpleader with $5,000 in their checking account or a disputed checking account. That's generally not a very great set of fees. So instead of belaboring everything, I anticipate that there will be attorney's fees awarded to the interpleaders. How much will be dependent upon what kind of work was necessary to get this in, and also whether or not the responses to discovery is a necessary part of the interpleader action itself. So that is way premature at this time to start talking about what interpleader attorney's fees might exist. Just that they're going to exist. There's going to be some. With respect to the motion to compel, my thought is it appears that it was necessary to file the motion in order to get us to this point and to get us to the point where Surge and Moss Creek are saying, okay, we'll give you some more discovery. But I'd like to hold that also in abeyance just a little bit. That meaning the amount, to see where we actually go with this, because I would like to give the interpleader Surge and Moss Creek a reasonable time to respond, not to avoid attorney's fees, but to respond to the discovery that should have been supplied, which might have, if previously done, avoided any necessity of attorney's fees. So right now, I'd like for us to focus on what that time frame should be. Mr. Murphy suggested 2 weeks. What is your suggestion, Mr. Kirby?
I would like 2 weeks to 4 weeks, best case scenario. That's what I would like, somewhere between 2 and 4 weeks. So maybe split it at 21 days.
$21 is fine with me.
Okay. Hold on a moment. I'm getting a note from our clerk over in Borden County. And let me see if I can get all of her note and see if it's something we might ought to address while we're all together. Oh. No, it's just she's asking about the papers that have been filed. I wonder, I might do something. Let me do this. Ms. Phipps, would you see if you could get Ms. Underwood on the line and give her the Zoom information and see if she can join us, so that
Yes,
if
sir.
we have a question that might that the parties might address, we could do it right now.
Okay.
I don't think she has any interest whatsoever in the amount of time needed to respond. 21 days is fine with the court. Ms. Wade or Mr. Ramirez, do you have any comment at all, although it's not your direct motion?
Nothing from me, Your Honor. 21 days sounds about right.
What I'm planning on doing, Judge, because we have similar issues with our discovery responses, and I was going to see kind of where the court went on what was ordered to be produced. So I'm just going to follow up with a letter to Mr. Kirby saying, when you amend your responses to the McBride heirs, please also take a look at ours and see if you can't do the same for ours.
Does that sound reasonable to you, Mr. Kirby?
My apologies. I mute myself. I'm in downtown. We have trains. I don't want to. Yes, we will. Upon receipt, we will review Ms. Wade's discovery request as well.
All right. If you're trying to big dog me, I just want you to know we have a train also.
No, not at all. It's loud, very loud.
Your Honor, for clarification purposes, I think everyone's on board with 3 weeks, but I would like you to give guidance regarding what Surge and Moss Creek are required to do if their objections, if they're allowed to stand and just amend the objections, or if those are stricken. Just want to make sure we're not here in 3 or 4 weeks debating what exactly Surge and Moss Creek are going to be doing.
Well, I anticipate we're going to be back in a few weeks, no matter what. My thought is I accept Mr. Kirby's representation, and I'm going to be admitting the district clerk.
Judge,
Yes. Yes.
I'm sorry. I'm told that Jana doesn't have audio. So I don't know if this is going to work.
Okay. Does she have video? Maybe she can lip read. Well,
It says she's connected now.
it does say that. Ms. Underwood, can you hear us? If she can, she doesn't have the audio to tell us. All right, let's go on with our conversation. What I was addressing is Mr. Murphy's point, and I started to say I accept Mr. Kirby's representation that they will withdraw some objections. And I would like to give you a suggestion of my thinking, and that is that if this information is discoverable, and I thought there was a basic understanding in our conversation that it was discoverable, then the objections are not going to be very well taken. If some of the material is supplied subject to objections, that's a different story. And what I think we will end up doing is, if there are objections that Surge still believes should be sustained, I'll take those up and I'll rule on those. But otherwise, I expect the material to be supplied, the material requested to be supplied. And then and for illustration purposes, Mr. Murphy, let's suppose for a moment that with or without objections, Mr. Murphy supplies all the material to you that you're discovery requests asked for. Then how you would be able to use the material might come into place subject to the objections. But if you would have it, you could then be planning on how you would be able to use it. The point I'm getting at is the attorney's fees point. If he supplies everything to you with or without objections, then I've already said, I believe you're entitled to some attorney's fees for having to get us to this point, but they would be less than they would be if he doesn't supply all of it and we have to come back and me rule specifically on the objections and whether or not it was in fact material that was in compliance with the discovery request. I'm a very conservative person and a very conservative judge by my own account, but I'm somewhat liberal when it comes to discovery. Cases can't be disposed of without discovery. And so, again, that is just a hint to you, Mr. Kirby, and your clients of what I would be on the end of the spectrum that suggests discovery should be liberally granted.
Understood, Your Honor.
Okay. And Ms. Wade's suggestion, I think we could perhaps save another hearing by treating her requests in a similar fashion that you're about to treat Mr. Murphy's requests. And if so, then that should hopefully save us from having another hearing on a very, very similar motion to compel. Okay. Anything else that we need to address?
Perhaps it's premature since we still don't have any answers from the new overriding royalty interest parties, but I know when we last met in early August, we talked about reconvening the scheduling conference for some point in October. And maybe it's too early to schedule it, but at least in terms of, as you said, Your Honor, we'll probably be discussing this again anyways, suggests that the scheduling conference be at least a week after, and it sounds like it's going to have to be because not all the parties have been served, at least a week after Mr. Kirby has done all of his responses. That way we can take up both scheduling and any pending discovery matters all at once.
All right, it's a fair observation. Let me also tell you that one of the reasons we are having this particular conference by Zoom is because I haven't taken the steps to get us approved, us meaning me, Borden County, approved to have in-person hearings. I have, it has been a bit of a journey, primarily because Borden County doesn't have any COVID cases and never has. We also don't have, therefore we don't have any local health authority. There is no medical personnel situated in Borden County. And I told this story to another Zoom conference that's also situated in Borden County this morning, another oil and gas case. And I won't belabor you with it because I can make it very long and very boring. The long and the short of it is I have finally discovered where the local health authority is for Borden County. I was first told that it was in El Paso. Look at your map. That's about 400 miles. Then I was, and so it took me a while to get a hold of El Paso and find the right person. I found the right person, and they said, no, we have traded Borden County and you need to go to Midland. Well, Midland is a lot closer. So I go to Midland and that makes a little bit more sense. And Midland says, no, we've traded counties and Borden County now belongs to Lubbock County. I finally found the right person in Lubbock County 2 weeks ago and spoke with him, and they do not have an acting regional director. He is the assistant regional director, and he is not a physician. The acting regional director for Lubbock County is a physician in San Antonio. Yes. And so, but I was told that they are acting very, very quickly and it wouldn't take any time at all to get our plan reviewed. We submitted it and we still had not heard. And I contacted Lubbock again yesterday and they promised to get in touch with San Antonio and get San Antonio back in touch with me. And lo and behold, this morning I have an email from San Antonio that said, thumbs up on your plan. You're good to go. So the next time we have a hearing, we will have the hearing in person in Borden County. And Ms. Wade, as a fellow West Texan, and I will give you a warm West Texas welcome and let you take us out to eat at the fancy steak dinner place in Gale, Texas. Oh, that's right. There's not one. Oh, shucks. Maybe we can get the train to deliver steaks for us.
Maybe we'll be able to arrange that.
All right. But our next hearing, if it's in the latter part of October, well, if it's in October at all, will be in person. So when would you like to suggest we set on our calendar a scheduling conference?
Should we wait until the new attorneys make their appearances?
You know, I think that's a good idea. We need to get everybody in the case so that they can participate. They may be kicking and screaming if they're in there one day or 1 week, but they're going to be kicking and screaming if they're in there 1 month or 3 months. So they might as well get in the party and we will have a better opportunity to set real schedules going towards trial. And my now my clerk sends me a message, my Borden County clerk, to remind me that early voting, not mail-in voting, but early voting starts October 13 and goes through October 30. And election day, if we don't already know, is November 3rd. As the county clerk, as well as the district clerk, she is responsible for voting over there. She tells me she casts all the votes for everybody. And her friends get to vote several times. But that can create a little bit of a problem with the courtroom being available. She has on past occasions used that for some of the voting. With that in mind, what are your thoughts on scheduling a scheduling conference? Or would you want to wait until we get these others with an actual answer on file?
Your Honor, it would seem like with election issues, with some of the new parties still not even being served, that perhaps waiting till November might be the best bet anyways. That way, courtroom's not gonna have to deal with election stuff. We can all drive down there, including the new parties, and everyone's involved in the case all at the same time, and they don't have to complain about it being one day after they file an answer.
I would agree.
Mr. Furby, are you driving down here or are you taking the train?
Would probably fly to Midland and then drive over, Your Honor.
All right.
We can
Well,
carpool, Mr. Kirby. I'm in the Woodlands.
oh, I thought you were in Fort Worth.
I moved.
Oh, okay. Good. Well, we could maybe do that.
Maybe you settle with me away. No, that's right. It's you and Miss Wade that needs to do the session.
I was gonna say, well, if that's the case, I'm gonna fly to Houston and then ride with them.
Yes. All right.
I'll pick you up, Eddie.
That sounds good.
What date would you like to look at? Let me suggest, now that I just asked you, let me suggest I would tell you everybody's favorite day, Friday, November 13. Although, let me tell you that the first 2 weeks of November are not good with the court's schedule as it already exists. I'm probably, man, we've got some jury trial issues. We have had 2 jury trials, and we're planning to have another one in October, and hope to have one in November off of our criminal docket. And if so, that's going to be November 16. Let me ask you, Monday or Tuesday of Thanksgiving week, does that cause problems for you, any of you?
That's,
Your Honor.
I'm
That's
good that
Not
week.
for me, Your Honor.
Your Honor, my wife and I have a baby coming on November 19th, but I can have somebody from my office make an appearance for me.
All right. Well, we do not want to interfere with that.
You'd have to answer to my wife, Your Honor.
Yes, as I say, we do not want to interfere with that. But if someone from your office, all right, and I'm getting a note from my clerk who's listening in, by the way, not sure why, apparently she doesn't have audio because she's not speaking. She might just be reticent about speaking in public. Ms. Phipps, did we use October 23rd? My clerk is telling me that they will make the courtroom available. We'll make it work for us if we wanted to do it sooner. But I think we were talking November is probably a better timing matter considering the new parties. So let's look at Monday, the 23rd or Tuesday, the 24th of November for a scheduling conference. And if we haven't resolved discovery before then, we will hear discovery issues on that date as well. On the same date that we do a scheduling conference.
Okay.
And so is Monday better for you, or Tuesday, 23rd or 24th, for those of you who will be coming down to see us?
What time would you want the hearing, in the afternoon or the morning, Your Honor?
I will suit it to y'all's schedule. I don't, those are 2 days I do not have anything currently set.
I'm
I'm
open to
driving,
whatever
so
works
I
for
will
y'all.
prefer-
Mr. Murphy, you first.
I'm open to either. I defer to all other counsel on that. I'm open on both of those days all time.
Ms. Wade?
I'm driving. I'm open on both of those days, and I can make whatever time work.
All right. Mr. Kirby?
Your Honor, both those days are open. I think from a scheduling perspective, on a travel perspective, I don't know if Mr. Ramirez or Mr. Murphy agree with this, but afternoon hearings might tend to lend a little bit better. I personally have never been to Borden County, so I don't know where I would stay other than Midland. And I've been to Midland several times, but I don't know what I would. I haven't looked at travel. That's my.
All right. Lubbock is just as accessible as
Okay.
Midland is. And the flight schedules are probably a little bit better in and out of Lubbock. But Midland may access Houston more than Lubbock. And so that is another, it could be a 6 and 1/2 dozen of the other, is really what I'm saying there. The oil field traffic in and around Midland is much more significant than it is around Lubbock. And so I literally have attorneys telling me they would rather avoid Midland because of the driving issues with the oil field traffic. With the price of oil down, there may not be as much activity right now, and therefore it may not be as significant. But if you'll do some research, you'll see that the personal injury attorney population is growing in Midland. And it's because of the oil field traffic, so I'm told. Again, it makes no difference to me. Let me suggest then that we meet at 1:30 on Monday afternoon, the 23rd. That way you'll have lesser chance of running into some early Thanksgiving travel that Tuesday might cause. So we'll say 1:30, and that's going to be for a scheduling conference. And we can take up some other matters. One of them we know might be, but hopefully will not be necessary, would be discovery issues. And let me tell you give you one piece of information that I think most lawyers from larger jurisdictions, like all of you are, who tell me they would like to get together and have an agreed scheduling order to present to the court. I appreciate all the work that attorneys do in that regard, but let me tell you, our scheduling conference and scheduling order in form is just like anybody else's, but in reality, it has a major difference. The major difference is when we walk out of that scheduling conference on November 23rd, we're going to have a trial date. It will be set in stone. It will not be changed. You will not have to worry about being the 7th case on the docket or the 27th case on the docket. You will be the first case, and you will be the only case. And so as you, sometimes attorneys come to me with an agreed scheduling order with the understanding that in the larger jurisdiction, if things need to be resolved or modified or continued or changed, that will put that trial date off to a later date, then that's just a part of it. That's not a part of it in our court. We will set you a trial date, a jury trial date, and we will go to trial on that jury trial date. And so if you spend any time talking about scheduling, try to make sure that all of the scheduling things that you think of in a scheduling order would not have the capacity to cause you to not be able to go to trial on that date. Because I will not grant a motion for continuance. I love telling stories. And one of my favorite stories is I had a scheduling conference, three attorneys, 3 parties, 1 defendant, 2 plaintiffs, and 3 weeks, and I gave them that same spiel I gave you. 3 weeks before that jury trial was set to go, one of the attorneys called and said, we have a joint and agreed motion for continuance to continue the jury trial. Can I just send the order over? And my coordinator put the attorney on hold and spoke to me. And then after talking to me, told the attorney, got back on the phone and told the attorney, well, it kind of depends. Do you want to have a hearing or not? And he said, why do we need a hearing? And she said, I'm trying to remember exactly how it went. I can tell you now that your motion is denied, or you can have a hearing and the judge will tell you that it's denied after the hearing. They didn't really, and after the hearing, I denied their motion for continuance. Their question to me was, give us one good reason, very respectful. They were good lawyers, very respectful. Give us one good reason why you wouldn't grant the joint agreed motion for continuance, which caught me off guard for a moment. And so I gathered myself and I said, if I grant your motion for continuance, you will have no reason to ever believe me again. I told you this case is going to trial. You can believe me when I tell you something. So this case is going to trial. The next day they submitted a settlement of the entire case. And so just remember, and maybe you can work things together and come up with ideas about what you want in your scheduling order and what dates and so forth. And I will be very attentive. It's your scheduling, it's your case, not mine. But when we walk out of there, we're going to have a jury trial date that we will have a jury trial on, your jury trial, unless you have the case settled before then. Do we need to take up anything else while you're all here? Ms. Underwood, can you hear us? Can you speak? Okay, she can't speak. Anything else? Yes?
No, Your Honor.
No, Judge.
All
No,
right,
Your Honor.
Let me
No,
see.
Your Honor.
Okay, I just got a note from the clerk that she can hear me, but she can't speak. I appreciate you all. I appreciate how we've conducted this. Let's get that discovery those issues resolved so we don't have to have other court actions. Ultimately, I've already said, Mr. Murphy, you're entitled to some attorney's fees to get this accomplished. If y'all can get that resolved as well, that's good. If not, that's what we have a court for. I'll make decisions. Don't mind doing so. All right. Thank you.
Thank you, Judge.
All right. Thank you, Your Honor.
A great
Thank you.
October and a fortunate election.
I will see you in the morning in Snyder.
Oh, really?
Yes.
We look forward to it. See you then.
Thanks, y'all.
Bye.
Bye-bye.